What happens to my personal injury settlement if I file Chapter 7? Have you ever wondered what happens to your personal injury settlement if you file for Chapter 7 bankruptcy? This is an important question for anyone considering bankruptcy while dealing with a personal injury claim. Let's break it down so you know what to expect. When you file for Chapter 7 bankruptcy, your personal injury settlement can become part of your bankruptcy estate. This means that if your injury occurred before you filed, the bankruptcy trustee may be able to claim those settlement funds to pay your creditors. However, the specifics depend on the timing of your injury and the exemption laws in your state. If your injury happened before you filed for bankruptcy, the settlement is usually treated as an asset. The trustee may pursue the claim or take control of any settlement proceeds. On the other hand, if your injury occurred after you filed for Chapter 7, the settlement money typically does not become part of the bankruptcy estate. In this case, it usually goes directly to you, free from creditor claims. It is essential to disclose any personal injury claims when filing for bankruptcy. Not doing so can lead to legal issues or even dismissal of your case. The bankruptcy trustee plays a significant role in personal injury claims. They may decide to pursue an ongoing claim on behalf of the estate, which includes deciding whether to litigate or accept a settlement. If the trustee finds the claim too difficult or costly, they may abandon it, allowing the claim to revert to you. Exemption laws are crucial when it comes to protecting your settlement funds. Both federal and state laws determine how much of your personal injury settlement can be protected from creditors. Some states have specific exemptions for personal injury settlements, which may allow you to keep part or all of the settlement. For instance, federal bankruptcy law includes exemptions that may protect certain settlement funds related to personal injury. Once a settlement is reached, your personal injury attorney will work with the trustee to allocate the proceeds. Medical bills with liens may be paid from the settlement, and the trustee will distribute the remaining funds to creditors. If there is any money left after paying creditors and expenses, it may be returned to you. Any leftover settlement money after paying creditors typically goes into the bankruptcy estate to help pay other debts. You usually do not get to keep any leftover settlement money unless it is exempt. It's also worth noting the differences between Chapter 7 and Chapter 13 bankruptcy. In Chapter 7, the trustee is more likely to claim your personal injury settlement to pay creditors. However, in Chapter 13, the treatment of your settlement depends on your repayment plan. You may be able to keep more of your settlement if your plan requires full repayment of unsecured debts. In summary, filing for Chapter 7 bankruptcy can put your personal injury settlement at risk if the injury occurred before filing. Understanding the timing of your injury and the exemption laws in your state is essential. Consulting with a bankruptcy attorney who knows your state's laws can help you protect your settlement as much as possible.